That's what gun control is all about. The ultimate goal is an unarmed and subjugated America.
Second Amendment protects firearms in common use at the time and also said this, quote, for lawful purposes like self-defense.
Getting assault weapons, AR-15s, out of the hands of people who shouldn't have them.
If you were serious, you would acknowledge that 96% of mass public shootings happen in an area where guns are banned.
Here's a 12-round magazine. This magazine would be banned under this current bill. It doesn't fit.
Breaking news. The Road v. Bonta ammunition restriction case from California. U.S. Supreme Court rulings and impact on gun rights. The 9th U.S. Circuit Court of Appeals found 7-4 that the statute only limits the size of mags that can be used with rifles, not any specific weapons, and overturned the decision reached by 2 justices to uphold California's ban on high-capacity mags. There is no proof that anyone has ever been able to defend their house and family because they did not have access to a large capacity mag, according to the majority, who also claimed that the restriction saves lives. Gun rights organizations intend to appeal the U.S. Supreme Court's decision. Their efforts to get cases involving firearms heard there have been directed at a high court that has a tendency to learn more to the right as a result of selections made by the former President Donald Trump. According to 9th Circuit Judge Patrick Bumatai, who was chosen by Trump, large capacity mags are commonly used by Americans for self-defense. According to him, these mags are standard on the most popular firearms sold today.
Thousands of weapons that got stolen and then recirculated because there was no proof of them being sold anywhere.
You are issued weapons that allow for fully automatic and 3-round bursts. That is not available for purchase.
And are lawfully owned by millions of people across the nation. The majority of the 9th Circuit chose the more stringent standard, determining that intermediate scrutiny was justified because the restriction only marginally interfered with the basic right to keep and bear arms protected by the Second Amendment. The Supreme Court is anticipated to decide on a lower legal standard for Second Amendment concerns in its impending decision on a New York concealed weapons rule, which gun rights supporters are hoping will happen. A more plausible prospect for such a verdict is the unresolved New York case. Legal professionals think that the verdict is more likely to be rendered in the New York case. Jonathan Lowy, the head of legal counsel for the Brady Gun Control Advocacy Group, said that the majority decision of the court was correct in holding that the Constitution, properly understood, does not prevent Americans from enacting the gun laws they want and need to protect their families and communities, and it does not entitle people to weapons of war. The U.S. Supreme Court has rejected the San Diego case ruling that supported California's ban on gun mags that may hold more than 10 bullets and remanded the issue to a lower court for further review. Additionally, this ruling eliminates a roadblock in other ongoing legal proceedings challenging the state's assault weapon ban. Leading gun control advocates, Everytown for Gun Safety, asserted that the state's appeal of Berettas' ruling to invalidate California's assault weapon restrictions this year was on hold, while the 9th Circuit considered the ban on high-capacity mags. In light of the ruling that Americans have the right to carry a gun outside the home, the Supreme Court directed lower courts to re-examine a number of cases that were awaiting the top court's decision.
Could lose the ability to use these tools and as a result may not be able to operate their firearm.
Banning a class of weapons that you don't like the look of, not because of functionality.
Examples of such laws are Hawaii's rule restriction who can carry a gun outside the home and Maryland's ban on assault weapons. In the New York decision, the court's conservative majority have new guidance to lower courts on how to evaluate gun regulations. Judges, according to their argument, should only take into account whether current gun control measures are consistent with the text and historical understandings of the Second Amendment. They will be able to apply this new guidance to other gun cases that are sent back to lower courts. The Supreme Court ordered the 9th U.S. Circuit Court of Appeals to re-evaluate its 7-4 ruling from a year ago that upheld California's ban on mags that may hold more than 10 bullets. The order extends the duration of the San Diego-based case's legal proceedings, rather than the 15-round limit that has been in place since 1990. A 2018 New Jersey law limits the majority of the gun owners to mags that hold up to 10 rounds of ammunition. A lower court will now have to reconsider the Hawaii ruling. The Maryland lawsuit that disputed the state's 2013 ban on 45 different types of assault firearms was remanded by the Supreme Court for additional research.
That men and women in this country have the right to defend their own lives.
That you said that all assault weapons should be banned. Is that a fair statement?
To propose regulations to ban all devices that turn legal weapons into machine guns.
The Supreme Court had already dismissed a legal challenge to the law in 2017. The 19th Circuit took similar steps with a firearms case that disputed California's assault weapon ban. A 92nd Circuit 3-judge panel remanded the case to the Los Angeles District Court so that the lower court judge might reconsider it in light of the new standards. The Supreme Court has overturned a lower court's ruling that rejected the lawsuit brought by gun owners and the New York chapter of the National Rifle Association, NRA, against a law protecting the right to bear arms. The majority of conservatives tend to regard Second Amendment rights broadly. In more than a decade, this was the court's most important ruling on gun rights. For the first time in 2008, the court recognized a person's right to have weapons at home for self-defense. The court expanded its recognition to include the states in 2010. According to New York law, anyone requesting limitless concealed carry permits had to convince a state licensing officer that they actually needed a gun for self-defense.
The pistol brace also does not help the shooter load the pistol more quickly.
Here's a 12-round magazine. This magazine would be banned under this current bill. It doesn't fit.
It wasn't the fully automatic machine gun that was banned in 1986. It wasn't the bump stock.
Most applicants received unrestricted licenses, which can only be used for specific purposes. The judgment made it more obvious how courts must now decide whether regulations are lawful under the Second Amendment, demanding that they be similar to those with restrictions that have traditionally been created throughout American history. Thomas claimed that the New York concealed weapons statute fell short of this standard. Advocates for gun control were concerned that the ruling may invalidate laws that prohibit the sale of untraceable ghost guns made from online parts, increased criminal background checks for gun buyers, and red flag regulations that target the firearms of people judged dangerous by the courts. At least 6 states, including the District of Columbia, New York, California, Hawaii, Maryland, Massachusetts, and New Jersey will be immediately impacted by the decision. The ruling permits states to prohibit the use of weapons in sensitive places, which might include locations other than the typical examples of this category, such courthouses and legislative buildings. Tom King, the president of the New York State Rifle and Pistol Association, the state chapter of the National Rifle Association, NRA, told Reuters that he would prefer to see as few places designated as sensitive as possible, and that he would file legal challenges if authorities try to ban firearms on subways or buses. Gun rights and legal challenges. The Maryland ban on assault-style rifles, as well as the bans on large-capacity ammunition mags in New Jersey and California, have all been invalidated by the U.S. Supreme Court. The ruling, which increased individual gun rights, sent a number of cases back to lower courts for further review. The ruling also clarified how courts must now assess whether restrictions are lawful under the Second Amendment of the U.S. Constitution, which requires that they be comparable to restrictions that have traditionally been established throughout American history. Gun control advocates are concerned that if courts use this standard, more gun regulations may be struck down nationwide, according to legal experts. The court's judgment represented its most important statement on gun rights in almost 10 years. Judges are divided and hesitant as a result of the Bruin decision from the U.S. Supreme Court, which has increased the number of conflicting decisions. According to the Supreme Court's criterion, the government must show that a gun restriction is in keeping with the country's historical tradition of firearm regulation. This resulted in Delaware's ban on the possession of handcrafted ghost guns, Texas' restriction on the ownership of firearms with their serial numbers erased, and the federal ban on gun ownership for young adults. The Supreme Court is expected to intervene to provide extra guidance for courts because to the legal confusion caused by the decision, which is the first significant gun ruling in 10 years.
how I am and my kids are going to be safer if I lock up my guns. I just feel, actually, as a female, I feel not as safe.
Getting assault weapons, AR-15s, out of the hands of people who shouldn't have them.
If you were serious, you would acknowledge that 96% of mass public shootings happen in an area where guns are banned.
The decision has led to different conclusions about the validity of some statutes. The legal disputes are taking place as the nation experiences more mass layings and as law enforcement officials work to reduce the rise in violent crime. Judicial arguments have been made in response to the Supreme Court's interpretation of the Second Amendment, with some proponents of gun control contending that the restrictions of the legislation will still apply to judicial challenges. The government was found to have failed to present a precedent from early American history that was sufficiently similar to the current legislation, according to the Fifth U.S. Circuit Court of Appeals. On this decision, Attorney General Merrick Garland intends to seek a second opinion. Gun control advocates counter that many restrictions will withstand judicial challenges. The court ruled that circumstances involving unheard-of societal issues or significant technology advancements may call for a more nuanced strategy. Both pro-gun rights and anti-gun rights organizations are keenly monitoring a number of ongoing challenges, including those contesting state laws banning particular semi-auto guns and high-capacity mags.
Second Amendment protects firearms in common use at the time and also said this, quote, for lawful purposes like self-defense.
They were assaulted and shot by someone and couldn't defend themselves because their guns were taken from them.
A few gun laws have already been invalidated, and some judges have deemed some parts of the new gun law in New York to be illegal. Publisher of a firearm mag KCI filed a Second Amendment lawsuit against the Protection of Lawful Commerce and Arms Act, PLCAA, and the Supreme Court is currently debating it. The dispute centers on whether KCI can be held accountable under the PLCAA for criminal action committed by other parties. The result might have an influence on the defense against unfounded allegations, which would have a big impact on companies that make weapons. After a shooting involving one of their mags, KCI, a provider of weapons manuals and mags, was looked into. It was discovered that the person who donated the mag was lying about having weapons and was unlawful in possession of one. In response, KCI filed a request for the lawsuit to be dismissed, claiming that their mag meets the requirements to be considered a component part of a firearm and therefore be given protections and immunities under the PLCAA.
That's what gun control is all about. The ultimate goal is an unarmed and subjugated America.
Our Second Amendment. It's a hell no to government trampling on our freedoms.
The KCI produced mag, however, did not fulfill the standards for being considered a component element of a firearm, and as a result, did not meet the standards to be eligible for the protections and immunities provided by the PLCAA. Given that the increase in civil liability would go beyond what the Constitution's framers intended, KCI contends that the Supreme Court ought to step in and decide in their favor. They argue that permitting the lower court to continue the case goes against the PLCAA's primary goal of dismissing claims before they result in drawn-out trials or expensive discovery procedures. Judge overturns California's gun purchase legislation. A federal judge blocked a California law requiring background checks for people buying ammunition, issuing a sharply worded rebuke of onerous and convoluted regulations that violate the constitutional right to bear arms. U.S. District Judge Roger Benitez in San Diego ruled in favor of the California Rifle and Pistol Association, which asked him to stop the checks and related restrictions on ammo sales.
He's likely to overturn our assault weapons ban.
Nothing's going to change for the foreseeable future. And when I say that, I mean for years.
The experiment has been tried. The casualties have been counted. California's new ammunition background check law misfires, and the Second Amendment rights to California citizens have been gravely injured. Benitez wrote in a 120-page opinion granting the group's motion for a preliminary injunction. Voters approved, toughening California's already strict firearms law in 2016, and the restrictions took effect. New York was the first state to require a comprehensive ammunition background check system for each sale, but it never took effect. That left California as the first to extend firearm background checks to each ammunition sale. 4 other states, Connecticut, Illinois, Massachusetts, and New Jersey, require buyers to undergo background checks to obtain firearms or ammunition licenses that they must show when buying bullets, according to the Giffords Law Center to Prevent Gun Violence. Hannah Shearer, the center's litigation director, called the ruling a dangerous step in the wrong direction at a time when gun stores are seeing increased sales to those worried about the effects of coronavirus on society or their safety. The law's red tape and state database errors made it impossible for hundreds of thousands of law-abiding Californians to purchase ammunition for sport or self-defense, said Chuck Mitchell, the association's general counsel. The court found that the flimsy reason offered by the government to justify these constitutional infringements were inadequate. He expected the state to appeal the ruling, but in the meantime, Californians can sleep a little easier tonight knowing their constitutional rights were restored and strengthened by this decision, he said. Governor Gavin Newsom championed the law before he became governor, and spokeswoman Vicky Waters said his administration is disappointed by the decision and considering its next steps. California's strong gun safety law helped keep our schools and communities safe, she said. The state attorney general's office said only that it is reviewing the decision. It did not immediately say if it will appeal or seek to stay the order, which takes effect immediately at a time when some California gun stores have been ordered shut because of the coronavirus. Among the places where the shops were not deemed essential businesses are Los Angeles and San Jose. The same judge's decision last year striking down the state's ban on high-capacity ammunition mags sparked a week-long buying frenzy before he halted sales while the state appeals his ruling. Gun owners similarly rushed to stockpile ammunitions before the new restrictions took effect last summer. Benitez called the ammunition background check law onerous and convoluted and constitutionally defective. Criminals, tyrants, and terrorists don't do background checks, he wrote. The background check experiments defies common sense while unduly and severely burdening the Second Amendment rights of every responsible, gun-owning citizen desiring to lawfully buy ammunition. While it is intended to keep ammunition from criminals, it's blocked sales to legitimate, law-abiding buyers about 16% of the time, he wrote. Moreover, he ruled that the state's ban on importing ammunition from outside California violates federal interstate commerce laws. Attorney General Xavier Becerra said in a court filing earlier this month that the background check stopped more than 750 people from buying bullets illegally from July 2019 through January 2020, not including those who didn't even try because they knew they weren't eligible. The law requires buyers who already are in the state's firearm background check database to pay a $1 fee each time they buy ammunition, while others can buy longer-term licenses if they do not have certain criminal convictions or mental health commitments. It took an average of less than 5 minutes to complete the background checks, according to state court filings. There is no substantial impediment, the state said in court documents. Ammunition purchasers must pass an eligibility check that, in the vast majority of cases, delays a purchase by a few minutes. Benitez ruled that the ammunition law illegally locks out of state vendors out of California's market, and that it conflicts with a federal law allowing gun owners to bring their firearms and ammunition through California. The lawsuit by California Rifle and Pistol Association was joined by out-of-state ammunition sellers and California residents, including Kim Rode. She has won 6 Olympic shooting medals. California's Road Bonta ammunition restriction case. The Road Bonta ammunition restriction case from California is one of the cases that California gun owners have been waiting for a really long time. Well, recently, there was a hearing in front of Judge Roger T. Benitez, and some additional things developed out of that hearing. Out of that hearing, we received some additional information that essentially needs to be covered. And some new things are being filed in this road case that many of you have been asking me about. Now, if you're not aware, Road Bonta deals with the state of California's restrictions on the purchase of ammunition and also the background check system or the eligibility check that a person must go through to purchase ammunition in the state of California. This provision was passed through Proposition 63, which requires purchasers of ammunition to undergo one of the two background check systems to confirm that you can legally purchase and possess ammunition. There is a basic eligibility check and then also the standard eligibility check, both of which come with their own different fees. This law in California also restricts the ability of someone from being able to purchase ammunition online and then have it sent directly to their home in California. All ammunition purchases, even online purchases, must go through an FFL, Federal Firearms Licensee. So, those are the ammunition restrictions which are being challenged in the Road v. Bolton case.
Similar to what we've seen in the past, we have to be ready for that.
The appellate court in the Ninth Circuit just remanded the case back.
Is it the most robust, far-reaching gun law in the history of the world? It is not.
Judge Roger T. Benitez originally reviewed this case and utilized the version of text as informed by history and tradition to reach his original decision. He described this test as the simple Heller test. He stated that Heller asks whether the law bans the types of arms commonly used for lawful purposes. He reiterated that it is simply a hardware test. Using this simple Heller test, he stated that it is obvious that the California background check laws that de facto completely block some law-abiding responsible citizens from buying common ammunition are unconstitutional. He pointed out that under the Heller test, the review could end at this first step, and he wouldn't need to go any further. However, also in that original order, he went on to find that an ammunition background check has no historical pedigree. In fact, he stated that a background check required each time ammunition is purchased has never been implemented ever before. So Benitez did exactly what the Supreme Court said should be done even before the Supreme Court issued their 63 decisions in New York State Rifle and Pistol Association versus Bruin. Updates on the restriction case. Benitez used text as informed by history and tradition to find that the California ammunition restriction is invalid. Road, along with other two-way cases, were sent back down to the lower courts for reconsideration in light of Bruin. Now, in December, there was a conference held in multiple California cases, which included the Road, Duncan, and Miller cases. Judge Benitez requested additional spreadsheets and historical evidence needed to be essentially submitted to him and to the court using the analysis in Bruin and trying to demonstrate the other historical analogs that are now required under Bruin.
District Court used a balancing test on public interest.
People thought that the federal government would never be able to get a gun law bill passed again. They got one done in the last year.
Rather than the New York State Rifle and Pistol Association versus Bruin test.
But since February, most of these cases, Miller, Duncan, and Road, have been pretty much silent. Recently, however, Judge Benitez has kind of brought Road back out of a holding pattern and held consolidated hearing in his own courtroom. Out of that hearing, Judge Benitez set some additional timelines for when information needs to be submitted to him so that he can finally decide this case. Now, with those orders of Judge Benitez ultimately boiled down to out of that hearing was that he's giving an additional 75 days to the parties to submit additional declarations and additional evidence that need to be submitted to him to support each side's position in the case. Judge Benitez gave the plaintiffs the ability to submit declarations to show that they are plaintiffs that then themselves do have standing. More importantly, he also gave the state of California some additional time to submit reports and declarations from experts, which, in California's eyes, should show that there is an American history and tradition of these types of restrictions on ammunition purchases that validates their background check system on ammunition, and also the restriction on people being able to purchase online and then having it sent to their home. But really, what this all amounted to was that there would be no full decision at the earliest until October, after all these additional documents were submitted to the court. Recently, the declarations from the plaintiffs was received to prove that they do have standing, and also California submitted additional evidence in support of their ammunition restrictions in these declarations of the plaintiffs. The Road ammunition case update. Road submitted the declaration, and she points out that she clearly has standing to sue the state of California and to sue against this law because she is an Olympic trap shooting competitor, and this law impacts her directly. So, for those of you asking for an update in Road and those of you asking what are all the documents that have been submitted in the Road case, those are some of the main takeaways. That's what's going on. Most of the additional briefs and responses are going to be due on October 7th, and that's when essentially we will now play the waiting game until after October 7th to see if Judge Benitez will finally issue his decision. But then again, California will certainly continue to make efforts to postpone this and, hopefully, this lawsuit. Road and all the other two-way cases are predestined to be heard by the 9th Circuit, where they will likely proceed through the procedure before being heard by the Supreme Court. That's all for this video, folks. See you next time.